There were things that happened right before DM created a new contact at 3:51 in the morning.
There was definitely a startling event around 4 in the morning when DM opened her door and sees an unknown person in black in the house.
We're talking about other communications with social media, with saving pictures, creating new contacts in one's cell phone right before the texting starts between DM and BF, and then subsequent to that, looking at pictures, editing pictures, calling family members. There's a much bigger picture than just this tiny little piece.
In the blizzard of documents that were released in March of 2025 in the Brian Kohberger Idaho 4 case, and the technical legal arguments about is it hearsay, is it a present sense impression, a lot went by. We're going to go back and take a look at the all-important question, what were Dylan and Bethany doing?
Hearing about everything that's been going on before, during, and after the M's has left me in a frozen shock phase. I'm Lainey Law.
And I'm attorney Andrew Myers, not in a frozen shock phase at all.
I mean, we've discussed on some previous episodes about some text messages and stuff going on during and before and after, but it's looking a little bit messier. And, you know, obviously we want to have sympathy and compassion for the surviving victims, but it's interesting to see how much our perspective on the case has been turned around with the information that's coming out.
Yeah, so a lot of documents went by, and a lot of us did the best we could to kind of swim our way through them and explain what we could about the documents. And as time goes on, and as the trial in the Kohberger case nears, you know, a jury selection in late July, the trial in early August, I was going back over some of it, and I was a little bit shocked at some things I had seen, but kind of went past. There was a motion by the state, by the prosecutors, to make sure that telephone records of Dylan Mortensen between the crucial hours of November 13th, 2022, between 2:10 and 4:37 in the morning. And the prosecution wants to get the phone records of Dylan Mortensen in, and Ann Taylor in making a very technical, legal, evidentiary argument that she did not think that all of it should come in because under the rules of evidence, it's not hearsay, and there's no exception. For example, the two big ones being present sense impression and excited utterance. So in making those arguments, Ann Taylor went through quite a colloquy of what were those girls doing that night.
A lot more to the text messages than the state has provided to the court, and the lot more makes a difference when you put all of these into context. The additional bits of information that are contained in that record around that same time frame, though, provide a much better context when we're talking about other communications with social media, with saving pictures, creating new contacts in one's cell phone right before the.
What are they doing editing pictures and adding new contacts in the middle of that night? What is Dylan Mortensen doing?
Well, drunk, editing pictures.
While being incredibly intoxicated, we went through the drinking, I think, in the previous episode on this case. But, you know, and again, this is before the crime was committed, but what are they doing?
The texting starts between DM and BF, and then subsequent to that, looking at pictures, editing pictures, calling family members. There's a much bigger picture than just this tiny little piece of texting between the two parties there at night. Further context about these messages the court should be aware that it's not just these messages. There's a lot more activity going on between these two people, and it's hard to tell what it is because there's telephone calls and those kinds of activities, as well as going down to one another's room, spending the time together, talking to each other, really take it out of an excited utterance, because it's an entire transaction between the two people. It's not just a tiny little piece of context with this group of text messaging. And the whole is what matters here, and takes it away from being excited utterances because of the other activities of the two people.
The activities that occur after, so for example, the texts between, at 4:18 or 4:20 or whatever, those aren't affected by the later activities of, surfing Instagram or whatever. And I'll be interested to hear the testimony of the two young ladies, because my experience with that age group has shown that where you or I might phone somebody, others might check out their social media to see where they're at or what they're doing.
Yes, Judge Hippler, that's exactly what they're going to do. And they're going to use things like Snapchat, thinking that nobody will know what they're saying. And we're going to look into that. Is that true?
Right. And so understanding how they're using those apps is also important.
It is important, and I would refer the court to our affidavit from Mr. Roloff, talking about the Snapchat activity, talking about Instagram, and there's a way to tell if somebody's active on Instagram versus just having it open in the background of their phone, and those are things that were going on, as well as editing pictures. The picture.
What pictures could they possibly have been editing in the middle of the night? Why are they editing them?
Well, the thing is, I just can't get over the fact that they're drunk, because if I had been drinking all day, I'd be like falling asleep in bed. I feel like you have to be almost pretty conscious to be going through. I mean, maybe they're just adding filters or whatever, but I don't know. It's so late in the morning.
Well, which is it? Was she in a frozen shock phase? Was she intoxicated? Was she sharp enough to notice bushy eyebrows and also sharp enough to be editing photos in the middle of the night? I mean, which is it? I can't think all those things are true. I don't know. I'm no neurological expert to know what you can and can't do if you're in a frozen shock phase, as alleged by the prosecution, or if you're as intoxicated as, Ann Taylor in the previous episode had run through all of the many things that Ms. Mortensen allegedly had been engaged in, a drinking game, drinking hard alcohol, and all the rest. So I don't know which it is, but the records, the forensic records of Snapchat and Instagram and the texts, which we went over in a previous episode, they're going to tell us a lot.
Editing happened in those overnight hours. Instagram happened later in that morning.
Wouldn't affect the excited utterance and present sense impression of the earlier 4 o'clock text, I guess is my point, because those are afterwards. Those are after they retreated to the room together, and what happened there.
Mostly I agree. There were things that happened right before. DM created a new contact at 3:51 in the morning.
3:51 in the morning. 3:51 in the morning. Under the state of Idaho's timeline, these murders, I said it, occurred between, 4:12, 4:17, 4:18, 4:20. So isn't it a little bit suspicious that she adds a new contact at 3:51 in the morning? And that's right around the time that the DoorDash guy was about to deliver the food to Xana. It just raises a lot of questions. That's all I can really say.
Yeah, and ultimately, for anybody watching this right now, because we did get comments in the past saying like, "Oh, you guys are so this, you guys are so that." Like, ultimately, we're just commenting on what they're discussing right here. We're not saying what's right, what's wrong. We're just saying that we're just pointing out the inconsistencies with this, and also like just the fact that this person is supposedly intoxicated. They're adding new contacts and very alert and awake at this odd hours, which I myself am guilty of. Andrew's definitely gotten emails from me at 3 a.m. but
I have. I slept right through them if you did.
But-
Emails. Yeah, emails, because they're on my laptop downstairs, so I'm sleeping up. Okay, all right.
Yeah.
Right.
So I'm not saying that it's anything like super crazy for this college-aged girl to be up, but it's just a lot of activity and it's just strange and it just goes against a lot of what we've said. And like I said, I mentioned, we're not trying to victim blame or put this towards any malintent towards the victims. We're just pointing out that this is all just very strange. I mean, Tinder and stuff exists. People are chatting online, doing whatever on your Instagram. You're messaging people and getting people's numbers. But it's just interesting 4 a.m. activity to be happening on
Well,
an eventful
all of
night.
this blows a hole in the initial probable cause affidavits. If you look at Jeffrey Nye, who's right in the upper right hand of the 3 pictures, in the upper right hand picture, he is right behind Ann Taylor. He kind of looks like, what the heck is this? And Bill Thompson has kind of a what kind of look on his face as all of this unfolds.
Before anything happened that was of an excited nature.
If you accept the state's timeline for that, and we don't know that yet.
The foundation that will have to be laid, but that's their version of the time events, and that's then the jury's job to figure that out.
Shortly after the last text message, and I'm talking just minutes, DM and BF are doing different things on their phone that night as they get together that night. There's the period of time that they're together in that room, both before there's a break in activity. There's not really a break in DM's phone. That is pretty well continuous.
So that was the clip I wanted to take a look at and figure out, the relevance of all of it. And I should say that Ann Taylor mentioned an affidavit of one of their experts. So a lot has been said about Cy Ray, the big expert in the case. But Ann Taylor, during the clip that we just played, mentioned their expert, Josiah Roloff. And this was filed in their amended notice of filing a declaration in support of the defendant's objection to the state's motion in limine regarding the text messages and testimony. And this is the defense's expert, Josiah Roloff, and he goes through his credentials as a forensics examiner at the company Roloff Digital Forensics. His background is in digital forensics, including a professional certificate in computer forensics. And it goes on, and that's all well and good. So we'll stipulate that he knows his forensic digital technology. We jump down to paragraph 9. I have reviewed the documents titled DM 11.13 bubble format and BM 11.13 bubble format, which contains data extracted from mobile devices used by individuals identified as DM, Dylan Mortensen, and BM. Notice that it doesn't say BF, it says BM. Who is BM? Well, Dylan's father is Brent Mortensen, respectively. These documents reflect periods of activity on the mobile devices that would require user interaction with the device for them to occur, specifically for the date of November 13, 2022. So those documents include artifacts and content demonstrating a variety of user interactions, including incoming and outgoing native text messages. I take that to mean just the normal texts that we all do. Incoming and outgoing Snapchat message artifacts indicated by the application identifier Com Toyo PA Group Peekaboo. Who is Com Toyo PA Group Peekaboo? That's the company that owns Snapchat. That's the software owner for Snapchat. Voice and video calls conducted via Snapchat and the native phone dialer. Look at that. He has voice and video calls conducted via Snapchat and the native phone dialer. creation, modification, and deletion of multimedia files such as images and videos, application usage logs showing when specific apps were opened and closed, and internet browsing artifacts and cookie data showing access to particular websites or internet-based services. So we all know that cookies are, I guess most of us have learned that cookies are there. You can wipe them. Some forensics examiners can go in and find them even after you delete them. But the interesting thing I found here was that they claim that they have voice and video calls conducted via Snapchat. And I thought it's ephemeral texting, right? Or ephemeral internet communication. In other words, you can set how long it stays on there. But if you're Snapchatting with someone, is that a verb, Snapchatting? If you're Snapchatting with someone, you show them a picture, it goes away. They show you a picture, it goes away. And it's used for some various nefarious activities that we don't need to go into. But, that was my understanding. But apparently, it is not the easiest thing to do, and I couldn't do it, but apparently Snapchat stuff can be found. I found this article in the Journal of Theoretical and Applied Information Technology, the digital forensic analysis of Snapchat application using XML records. And we're not going to read through the whole thing, but the issue here is that researchers observed whether or not metadata traced relating to images and videos, location that have been sent by the users, where Snapchat saves the files sent by them. The previous researchers found digital evidences of XML records relating to Snapchat in saving images on a folder named Snapchat Android _preferences XML. The folder contains important information. The other thing is existence of a folder named Received Images Snaps. It contains programs for removing files. It is, and there's the name of it, if a directory has a file named No Media Extension, so the hardware saving media would not scan and recorded metadata file in the directory. Therefore, this research is expected to reveal where Snapchat saves the data, how to recover images or video, and how the correlation between the XML records and image name on Snapchat. Therefore, it is important to know the related files in XML records and image name to ease and accelerate investigation process. So I found this interesting. I always, just assumed that, and I don't even know what to do with Snapchat. You know me. I'm technically not on a scale of 1 to 10, 10 being an expert. I'm probably like, a 1.5. So most of us thought that the Snapchat stuff is not available, but this article goes way deep into the technical aspects of it, and that apparently some Snapchat data is there. And the thing that really was the dent motion for me as I skimmed this article was that location data can be retrieved forensically, which is important because there are those who say Bethany Funke and Dylan Mortensen, or maybe at least Bethany Funke, was not at 1122 King Road the night of, or all of the night of November 13, 2022. So I found that interesting. If all of this pans out, we may get we just heard the judge and Ann Taylor, the judge assuming that Bethany and Dylan were both home. But were they? So, this article digs way deep into how to do it. The information architecture of Snapchat. This could be an entire semester of study right here. They talked about their methodology and, all the rest. So we are going to jump. Lane, you might be able to read all this kind of stuff.
I was going to say it logically makes sense because when you do get a Snapchat, you can actually see the history kind of a snap. It'll say so-and-so sent you the snap. So it does make sense that there would be some type of log where it's just not completely disappearing.
So the conclusion, because, forget all the stuff in between. The investigation process conducted on Apple 6 and Samsung Note 3 relating to the research on Snapchat application concludes the important file of iOS is comtopoya picaboo PLIS. I know, I'm not going to read all the letters. And user PLIS, whereas the structure in Android devices is com Snapchat Android _preferences XML. Okay. iOS devices use file acquisition system. The files of both image and video are not found, but there is a file showing the removed images and videos. In Android device, the file of both images and videos can be found, as well as metadata track. It can be viewed clearly. The writers started this research for answering the question whether or not the Snapchat file is permanently removed. A fact has been revealed that chatting file on iOS with forensic methods still leaves notes, although the image and videos are fully detected. Whereas the devices with Android uses physical acquisition on image or video files. They are not permanently removed. They are hidden with no media extension, so they are not displayed or viewed in a gallery. So we go back to this affidavit, and I just found it really interesting that under paragraph 9, they were talking about data extracted from mobile devices used by individuals identified as Dylan Mortensen and BM Brett Mortensen. And I've seen some other people say it's Dylan and Bethany, but the document clearly says BM. And I also found it really interesting that they're talking about incoming and outgoing Snapchat messages, artifacts indicated by the application. And they're also talking about, voice and video calls and location data. So that's the dent for this episode. That are they going to be able to finally answer the question that is out there? And we're not going down in the tunnels, but we are asking the question, are they going to be able to track where were Dylan and Bethany? Because I'm not totally convinced from what I've read, and I could care less about the PCA because Prosecutor William Thompson has himself said that the PCA is irrelevant at this point. Okay. So let's prove where the two girls were and what they were doing on their devices. So I don't know.
Well, I definitely think, especially with the context that we've been hearing a lot about this frozen shock phase, that it is relevant. And even with, the Snapchat artifacts, obviously, well, I say obviously, but people don't know what Snapchat is, that Snapchat does have location sharing features, and it actually does have like a little map where you can see and all of that stuff. And even beyond Snapchat, our phones are good at tracking the location of where we are and everything. So ultimately, I expect that everybody involved probably has an iPhone, so the amount of data that we'll be able to get is probably going to be relatively limited. But I do think the additional Snapchat information is going to help contextualize a bit of what was going on that night.
I think the bottom line is everything you ever do on your phone is public.
Yes.
I think the bottom line is everything you ever do on the internet is public. People think, we can go down into wherever we go and we're going to be private. No. So, a lot of our commenters have asked one question that I feel the need to answer. They're saying, you're telling us that the prosecution has the burden of proof, and theoretically the defense doesn't have to do anything. The defense doesn't have to put on witnesses. The defense doesn't have to present evidence. All they have to do is, cross-examine and point out that there is reasonable doubt. So if that's true, that the prosecution has the burden of proof and the defense doesn't have to do anything, how come we have heard so much about this alibi? Ashley Jenkins and William Thompson have really been pushing against Brian Kohberger for not coming up with much of a defense, much of an alibi, I should say. Why does Brian Kohberger have to say anything? And that's a question that we've gotten a lot. And so I felt the need to point out that everything that our commenters put in their questions about the burden of proof being on the prosecution and the defense not having to do anything is true. The defense doesn't have to do anything. But the alibi statutes in a lot of states, including Iowa, put a big if. They put a big if. If the defendant is going to raise an alibi at trial, they have to give the information in advance. This is Idaho Statute 19-519. Notice of defense of alibi at any time after arraignment before a magistrate upon a complaint and upon written demand of the prosecuting attorney, the defendant shall serve within 10 days or at such different time as the court may direct upon the prosecuting attorney a written notice of his intention to offer a defense of alibi. Such notice by the defendant shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. So this is where that Wawaii Park came in. They said, well, he likes to go there. They didn't specifically say he did go there. They said, well, he likes to go there and he likes to look at the stars, and that's his alibi. And he wasn't reporting to any phone towers. Well, that's not good enough, because if you read it closely, it says specific place or places, and it says what witnesses will be relied upon to establish that alibi. And that's not good enough. Of course, there's been none, but within 10 days after receipt of the defendant's notice of alibi, but in no event less than 10 days before trial, unless the court otherwise directs, the prosecuting attorney shall serve upon the defendant or his attorney a written notice stating the names and addresses of the witnesses upon whom the prosecution intends to rely to establish the defendant's presence at the scene of the alleged offense, and any other witnesses to be relied on to rebut testimony of the defendant's alibi witnesses. And it goes on. If prior to or during trial a party learns of an additional witness whose identity, if known, should have been included in the information furnished under subsection 1 or subsection 2 of this section, the party shall promptly notify the other party or his attorney of the existence and identity of such additional witnesses. So this is fairly technical, and it does require, again, no, the defendant ever, or in this case, Mr. Kohberger, doesn't have to say anything. They can remain silent all they want, can go into the trial every day and remain silent. But if there's going to be an alibi, they need to prepare in advance. And the reason for statutes similar to this in many states is because, the prosecution, the state, wants to have the ability to prepare for all of that. Now, number 4, upon the failure of either party to comply with the requirements of this section, the court may exclude the testimony of any undisclosed witness offered by such party as to the defendant's absence from or presence at the scene of the alleged offense. This section shall not limit the right of the defendant to testify on his own behalf. So, excuse me. There's a little bit of wiggle room. If I were the defense, I wouldn't rely upon it. But number 5, for good cause shown, the court may grant an exception to any of the requirements of sections 1 through 4. But again, that's wiggle room, and we attorneys don't like to have to rely on wiggle room. So Mr. Kohberger is, under the statute in Idaho, he is under some obligation to provide detailed information. And as we've seen, the prosecution is really pushing him on that issue.
I'm more surprised. And I think the lack of the proper alibi or a hard alibi is a reason why people either assume the guilt or lean towards guilt. I don't want to say biased. I am conflicted because and part of me is like, well, if this was actually happening, if he did just go out at night to look at the stars, then wouldn't his father be able to be one of those witnesses? Like, oh yeah, like he went out and like frequently. Then at the same time, it's just like, imagine just living your life and then getting, caught into police custody and then trying to figure out what you're doing that night. Is just like, well, sometimes that night I like to go out into the park. So I don't know. I hope that if anything ever happens and I am on trial for something, that I was at work during the time that anything happened. So I have a rock solid alibi, but it's going to be hard to fight with that. And I think I guess it's kind of like with the prosecution, the way that I see it is like they want a more concrete alibi from him, but ultimately that's going to be up for the juries to decide if he had a sufficient one or not. I think for a lot of people, and it kind of works out in the prosecution's benefit that he doesn't have a rock solid one, but at the same time, we're going to have to see how this plays out.
It's a challenge in this case because, for single people, where's the alibi? If you're single and you go home after school or work or whatever, and you go home and something happens, what's your alibi? Well, there's where your cell phone comes in. There's where your cell phone comes in, because 99% of the time there's location data that they're going to be able to dig out. But in this case, two things. A, that phone stopped reporting to the cell towers, but B, a forensic person can apparently dig in and find out where the phone was. So anyhow, our commenters have a lot of opinions on this case. They have a lot of opinions on this case.
So we have Concur 450. Sue was great. Please have her again. We were really lucky to have Sue on. And it's definitely interesting having a perspective from someone who was actually able to go to the hearing and hear the hearing directly instead of watching it. I can't believe that it's apparently been a no big issue to just get in there, because you would imagine that with such a global case that this would be, everybody would be trying to see these. But the hearings are long and a lot of people probably find them boring. So at the same time, I kind of get it.
Well, back in February, I talked to Sue. She's a regular contributor to our comment section. And I reached out to her back in February for the February hearing, but the audience was kicked out. About 2 days before that hearing, the court issued a notice that nobody can get in. So, I guess that changes from hearing to hearing, but yeah, we'll have her back. And she also sent me some really interesting video that she took driving around Moscow and that area. And so we'll use the video in a future episode. I just didn't have time to take a look at all of it. And it's good quality, what I did see, and we'll use it in the future. Okay, here we go with Philomena Braschi. I actually I had a neighbor named Philomena, so that's the only way I can pronounce that. I think Kohberger is being made a patsy for the crime. He couldn't kill 4 people on different floors in that amount of time that was given. I suspect Jack knows who. You didn't say which Jack. There's 2 of them. I suspect Jack knows who did it, or at least set it up. I don't know. Again, this is going down into the tunnels. I personally don't believe if he had anything to do with it, and I shake my head. I know I'm going to get grief about that in a minute, but I don't know if he did it, and if he did, I don't believe that one person did it. I just don't. I'm sorry, I just don't believe it.
Lars at 9. I bet when the judge redacts the 911 call, he redacts BF saying Xana was in all black, and DM replying, "Shut up." I hope not, because that goes to the surviving roommate's loss, considering the person in black was potentially someone they knew. I don't know. I don't think they're gonna I highly doubt they're gonna redact the 911 call at this point. What do you think, Andrew?
I think that if you let part of it in, you have to let it all in under the doctrine of completion. I mean, you need to. What's the jury going to think? I mean, I always wondered. I mean, I know there are technical, legal, evidentiary considerations to allow certain evidence and not allow certain evidence. But if you're in a jury and you hear the 911 call redacted, what are you thinking? I mean, what are they hiding? What can't we hear? Why aren't we allowed to hear the whole thing? So my guess is that, the judge was listening to Ann Taylor in the clip that we played earlier in this episode. She was saying, well, some of the conversations that were had were so remote in time that they don't come in under an excited utterance or present sense impression. Good argument. But my guess, I don't know. My guess is that he'll let it all in. I don't know. Okay, here's Medusa Echo. Here in Europe, the first thing you get as a kid is a Swiss knife. I remember Boy Scouts. So a lot of the kids had Swiss knife. I had a Boy Scout knife. I didn't have a Swiss knife, but I remember them. I was born in the former Yugoslavia, and elementary school starts at the age of 7, takes 8 years. And in the year 7 and 8, we had defense and protection first aid. Without the coroner's autopsy report, this knife shouldn't even be discussed, as just the sheath doesn't say anything, especially when we know that Ethan was bashed by some kind of a bat and then cut along his legs. It's just insane.
Disturbing.
Yeah, that knife sheath, without the knife. We talked about that in the last episode. How much of a search did they make? Of course, how do you find something that's as small? That's a big knife, but how do you find something that's that small in the Snake River, which has pretty fast current?
And even if you find the knife, how do you know it's the same knife? And there's
Yeah.
a million different things.
Yeah, and how,
The super magnet, bring it in. It's just like pull everything out of the water, drain them.
yeah, it's just, no, that's not happening. Okay, number 1.
David Edwards, the most Kohberger channel I have ever come across. Hope you all can see the evidence someday, smiley face. And then Queen BJG. I don't know if I'm going to listen to this much longer. It's so biased towards the defense. After all this, after all, I mean, the thing is just like I can empathize at some points where when we're pointing out the inconsistencies that it may seem that we're leaning one way or another. But at the end of the day, we're just trying to report on what we're seeing, what the jury's going to see, and our own opinions.
When I put this slide together, what I meant to do was put in, and we have received comments accusing us of being pro-burgers. And we've also gotten comments, we got one comment this week that I'm never going to listen to you again. I'm going to subscribe because you're a guilter. And it's like, this is the problem when you try and, maintain some sense of objectivity. We all know that there are channels out there that are guilters. I've been a forensic analyst for 50 years, and the police may have made some mistakes, and they did, but he's guilty, and we should convict him. And there's channels, on the other hand, that are in fact pro-burgers. I hate to use that word, but there's channels out there that say he's not guilty, and here's why. And so if you look at the evidence or read the documents with that filter in front of your eyes, you're going to see the world through that, and it's called confirmation bias. But we're trying really hard to maintain some objectivity up through the trial. We'll watch the trial. We'll cover the trial. And as an attorney, I really want to, maintain that presumption of innocence. I really do. I presume that he's innocent. I've said that I just don't think that one person did it. But, you have to admit that there's pretty strong evidence. I mean, if he did buy the knife, I know anybody can buy a knife. If he did buy the balaclava, I still can't say it right. A lot of people buy those things. If I don't buy the thing about Fuzzy Wuzzy was a car. Those videos really. But if they do have a clear video, which I haven't seen yet, people allegedly claim that they have purportedly seen it. But if they do have a clear video of the same car, that's not Fuzzy Wuzzy was a car, that is driving around and stops behind the property. That's. My mind is open. That's the only thing I'm trying to say.
And I do want to say, at least for myself, that like in the ideal scenario, at least in my opinion, I agree with Andrew in the fact that that's a lot of things to get done in such a short period of time. So it seems impractical. But ideally, he would be guilty, if only in the sense that that means that these people can go to bed safe at night. It's like we don't want to believe that there's someone out there that's not seeing justice for this. So our minds are more inclined to believe that he would be guilty just because it helps us sleep at night. We want the justice system to be working. We want to be able to trust what's happening, and we want to be able to trust that the situation is taken care of and nothing like this is ever going to happen again. So this is more coming, we're just talking about the case itself and just the parts that are confusing and strange and how the jury's going to interpret that, because at the end of the day, we all just want to be able to feel safe at home. So
absolutely. And I think a lot of jurors come into it thinking that way, and thinking that, we want the police to be right every time. And so, it's hard to find jurors. It was in the Karen Reed case, we did a episode where we mentioned of all of the many, many, many people that were in the initial veneer, not that many people hadn't heard the case and didn't have biases and didn't feel that they were going to be able to maintain objectivity. So it's a tough issue. It really is. But here we go. A little bit has trickled out. Remember before we had nothing at all. And it was just all going down into the tunnels and trying to guess what might have happened. At least now, in the last month or 6 weeks, a lot of documents have come out with some evidence. We don't have it all. I am still saying that I think there's some huge pieces of evidence that will be coming out that will shock us all. I mean, we could go into the docket. Right before we recorded this episode, I did go into the docket to check and see if there were any updates that we need to take a look at. And stuff is still being sealed. Discovery responses are being sealed. Orders are being sealed. So there's a reason for that. And, hopefully we will find out. We will find out because they're not going to withhold evidence at the trial, I wouldn't think. I don't think that they would withhold evidence at the trial. But then again, I've been called naive. So that is my closing thought, except to say, please subscribe to our channel. We don't sell stuff. We don't break in the middle and say, why don't you buy this? Why don't you call this stock sales company? We don't sell body lotion. There's enough of that elsewhere. I think that's one of the reasons that commercial television is going down the tubes. We don't sell you mugs or we don't sell you hoodies. So all we ask is that you just click that little button, subscribe. It only takes a half a second and it doesn't cost you a second. So that's the end of my rant. Your turn for your closing thoughts.
And as per usual, thank you guys so much for watching to the end. If you made it this far, be sure to like this video, leave a comment. Oh God, I don't even know what to say for that comment.
Well, a couple of weeks ago, we said leave a Red Sox emoji, and somebody said there is no Red Sox emoji.
Well, I said socks emoji.
Oh, you did? Okay.
I socks emoji
corrected.
specifically. I don't know the color of said socks. I don't know. Maybe we'll toss in some t-shirts of whatever color you want. But be sure to comment down below if you made it this far. Comment your opinions, what you think. Obviously, comment if you think he's guilty. Comment if you think he's innocent. Just feel free to use it as a place to express your opinions, preferably not insulting us directly as people, but even if you do, don't worry, I don't take it personally. But yeah, subscribe, comment, like the video. This is obviously a really terrible thing that's happened, and I do hope that the victims' families do see justice. And like I mentioned before, we want the surviving victims to be able to be in peace. The main issue at hand is simply that there's a lot of inconsistent information that's come out, and we wanted to just highlight that because that's going to become an issue at court.
So my final thought is this. In addition to the emojis, down in the comment sections, you let us know, were Dylan and Bethany home that night? And if they weren't, before I go to the grocery store now, if Dylan and Bethany were not home that night, where were they?
Whether you were in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comment section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.